Welcome back to another edition of Between Two FARS. I'm Warneke Miller, and I'm joined today by Judge Reid Prouty, who's Vice Chairman of the Armed Services Board of Contract Appeals. We're really glad to have Judge Prouty here today. He started his career with 7 years of active duty service for the Air Force, and then spent another 15 years working contract litigation for the Department of Justice. But then he joined the Armed Services Board of Contract Appeals and has been there the last 7 years. We'd like to just kick off this series with you by talking a little bit about the Armed Services Board of Contract Appeals. How did it get started?
Thanks for asking, Warneke. Basically, the boards of contract appeals were formed around World War I. For the big mobilization that came with that, it was recognized that there were going to be contract disputes. And at the time, there was no CDA. And it was recognized as well that with big contracts and the big contractors being willing to do things for the war effort, you needed to give them some sort of recompense or avenue for it if something went wrong. So that the service secretaries, sort of as an act of grace, created the boards of contract appeals. There was the War Department Board of Contract Appeals and the Navy Department Board of Contract Appeals. And those pretty much lasted the balance of World War I. And then when World War I was over and the demobilization happened, you didn't need BCAs anymore and they went away. Then came World War II. And with the really big mobilization that came along with that, again, they brought in boards of contract appeals. One for the War Department, one for the Navy Department. And again, these were sort of an act of secretarial grace. But of course, it was a grace that was in the best interests of the government because you wanted to be able to encourage contractors to do business with the United States. And now, as World War II wound down, our military commitment didn't quite wind down. So we continued to have boards of contract appeals surviving past the end of World War II. By 1962, the Armed Services Board of Contract Appeals got a statutory footing. And in 1978, of course, the Contract Disputes Act recognized explicitly the Armed Services Board of Contract Appeals and the various civilian boards of contract appeals that were later all merged into the Civilian Board of Contract Appeals. Now, the important takeaway from this is that they sort of started as an act of grace, which meant they were very, very informal. Basically, during the World War I era, you had sort of graybeards sitting around saying, well, this is fair and this is not fair, and here's what we should do. And then as time has gone on, it became more regular. You began to have written opinions. You began to have legal, following the law, so to speak, more than you did before as far as being an act of grace. So the informal boards, and the CDA sort of saw the boards as being a much more informal avenue than the Court of Federal Claims, became more and more formal. And this is really the important thing in contemporary board practice. If you look at the way our rules were set, in some ways are rather vague. And the reason for that is to give more space for there to be informality, ways to sort of get substantive justice. But the problem is that you have federal circuit review. And when you have review by review in court, people need to dot the I's and cross the T's more than they otherwise used to. So as time has gone on, the more formal, the more judicial-like trend is going to grow. So you'll see, in fact, that if you look at, say, an opinion from 30 years ago and an opinion from today, or sort of the track of the case from 30 years ago and the track today it's going to look a whole lot more formal, a whole lot more like what you see in the Court of Federal Claims. In fact, I would suggest that you'll find almost no substantive difference. We have pretty broad, pretty somewhat vague rules, but not that vague, on discovery and things like that. But at the end of the day, you go back to the federal rules of civil procedure to sort of fill in the blanks. Similarly, we are not bound by the federal rules of evidence, but they're pretty instructive to us. Now, the one big area that you'll see that we have some daylight between us and the regular federal rules is on hearsay. That is, that basically we can consider hearsay. However, even that, generally, if we're going to consider hearsay, we're going to want to have some reason to believe it's reliable. All of the usual hearsay exceptions. Now, again, we're not tied to the rules, the federal rules for hearsay. However, even those we're going to creep in just a little bit. So you're going to find that as time has gone on, the tension between the informal and the formal is moving more and more towards the formal as the board evolves.
That's fantastic. Thank you so much. It really helps us to understand why the board operates the way it does today based on this historical overview and the context for how we evolved into this current Armed Services Board of Contract Appeals. Stay with us because we're going to continue to talk with Judge Prouty and cover a multitude of issues ranging from litigation in front of the board to settling your contract disputes away from the board. So join us again next time on Between Two FARS.